So good morning and welcome to today's webinar. I'm Dana Moore, your Director of Broker Relations at North San Diego County Realtors. Today's webinar will be on two contracts, the PIA and DNA, which are the Property Images Agreement and Delivery Notice Addendum. Did you know that these are two of the most important forms, but the least understood and the most seldom used forms in the C.A.R. library? Find out why not using these forms may just cause you to cry all the way to the bank or put you and your client's transaction in jeopardy. Your presenter for this morning's webinar is Chris Hasvold, who many of you already know. He's the broker owner of Coldwell Banker Village Properties, the immediate past president of the North San Diego County Realtors, chairman of the Risk Reduction Committee, C.A.R. director, C.A.R. MLS board of director, and a member of C.A.R. Standard Form Committee. There's so much more I could share about Chris, but I don't want to take too much time away from his presentation. So without further ado, Chris Hasvold.
Thank you, Dana, and good morning. And let me commend everybody for taking the time out of your busy schedules to better yourself, because as Dana said, these are two of the most important, and I'll show you why, but two of the most important but least understood and least used forms that we have. So it's going to be a little different today on Zoom. I prefer to do this in person because we get a lot more interaction and feedback, but we'll do the best we can with the Zoom. So first answer to your question, which everyone's going to ask is this being recorded? Yes, it is being recorded, so it will be in our library. If you don't know, we have a great library of lots of presentations and webinars. It's nsdcar realtors tv.com. So it'll be recorded there. Probably by tomorrow, you'll be able to see it and get to your friends and people that couldn't make it today to watch. So as Dana said, I'm going to go ahead and do a share screen. I'll try and make this as interesting as possible. Anytime you start talking contracts, that's a challenge sometimes, but it's really important. So as Dana mentioned, why should you listen to me today? That's a good question. So as Dana said, I've been a broker for 40 years, closed over 7,000 transactions, member of the C.A.R. Standard Forms Committee. And if you don't know what that is, there was a committee of about 20 directors throughout the state of California that meet a few times a year with the C.A.R. attorneys, and we actually create or change every form that you use, including last year. For all the PEDs, everything that we had to do last year. If you want to scream at somebody, you can scream at me because I was part of that group. But I think sometimes we get a bad rap. People keep saying that we just create forms to make your life more difficult, and that's not the case. C.A.R. Standard Forms really is trying to provide us tools to function in the legal environment that we're in. So last year when we had a lockdown, for example, and we had these guidelines we had to follow that were state guidelines. C.A.R.'s job is to try and come up with a form that allows us to work within that environment. So that was the PED form, the different things like that. So all of the forms that we use again come through out of that committee, and I have been a part of that, so know them pretty well. Also Risk Reduction Committee Chairman. So most of my job in my company and what I do most every day is try and keep our agents and our clients out of trouble. Sorry, got crazy with the mouse there. Also on the C.A.R. MLS board of directors, so that we talk about MLS violations and policies and rules. I'm on the board of directors, so have a pretty good insight into that. Also, when I have time and if the case is interesting, I'll do some expert witness in real estate litigation, and that's always fun. Kind of work, but kind of fun. So first one we're going to talk about is the PIA. It's been out for at least 3 years. It's just been revised and will be changed in June for the revision. Oh, let me say this again. If you have questions, okay, I'd love to get lots of questions, but I think I'll answer most of those throughout the presentation. But if you have a question, go ahead and put it in the chat box. So type it in there. We'll be able to respond to it there. And then after we're done with the forms, I'd like to open it up and unmute your mics and we can just have a free-for-all, because that's would be my preference. So anyway, PIA form. PIA form was created, Property Images Agreement, to again solve a problem, and that problem was copyright violations. I know it's not a sexy saying, but what does copyright mean and why do I care? right? Most of us go through life and we think, who cares about copyright laws? Well, hopefully this will get your attention. So this is from a Q&A from C.A.R. And it says, what are the penalties and remedies for copyright infringement? Severe criminal and civil penalties exist for copyright infringement. The infringer may be liable to the copyright owner for, let's look at B, statutory damages ranging between $750 and $30,000 per work. So let me make sure you understand that. So if you're putting pictures online of your listings and they're copyright infringement, you put 75 pictures on MLS for your listing. And if you don't have the rights to do that, you can be fined between $750 and $30,000 per picture. So if you don't have your calculator handy, 7,500 or 75 pictures at $750 is a $56,000 fine. If it's 30,000, it's $2,250,000 you could be fined for copyright infringement for posting 75 photos in the MLS without permission. It's even worse. If the infringement was intentional, and intentional meaning you take a listing, it was on the market in the past, you or your seller don't want to pay to have professional pictures taken again, so you just use the pictures from the previous listing, that's certainly intentional. The fine can be up to $150,000 per photograph. Times 75 pictures, that's $11 million. So hopefully that gets your attention. Also potentially criminal offense and imprisonment for up to 10 years. Never seen that happen, but I guess it's possible. So hopefully that tells you why we're talking about this today. So you say, well, that's a law and nobody pays attention to it, right? Well, here was a lawsuit that actually was filed a couple years ago by a real estate photographer who sued Zillow for $81 million. And that the claim is the photographer said Zillow is using images without the photographer's permission. And there were 543 photos, it was $81 million lawsuit. So let's talk about that. And I can't see all of you guys, unfortunately. So how many of you actually know who owns the rights to a picture? You have a professional photographer take a picture, who owns the rights? Does the owner of the home, who it's his home, his or her home? Do you as the agent have the right because you're paying for those? Or is the photographer that owns that image? The law is, it's the individual that takes the photograph is the copyright owner. So the way to think about this is, obviously we're in the business of selling homes, maybe renting homes. If you own a home and you're going to rent it to a tenant, right, you still own it, but you give that tenant the right to occupy that property for a specific period of time, for a specific fee. And after that agreement is up, that reverts back to you, right? You're still the owner of the property. You never gave up ownership. You just gave someone a right to occupy it for a period of time. It's the same thing with copyright, same thing with a picture, right? Unless you, as the agent, are granted the correct license, you don't own those rights. So let's talk about the MLS. This is MLS rules, right? By submitting any media to the multiple listing service, the participant and subscriber represent and warrant that they own the right to reproduce and display the media, or they have procured such rights and all necessary licenses from appropriate parties. So let's talk about a couple different scenarios, right? You take the photos yourself. Who owns those? You do. No problem. You can put those in the MLS, no issue. However, if you hire a photographer to take the pictures on your behalf, that photographer is the one who owns those rights. Scenario 3, you stole the photos from another agent or website, right? Happens all the time. Sometimes really blatant, sometimes not. Let's talk about Google, right? You go online and you just pull pictures off of the internet. Do you have the rights to repost those in the MLS? The answer is no. Without permission, written permission from the photographer, Google, Bing, or whoever, it's an MLS violation of $1,500. And that's not negotiable. That just happens. You're just fined, right? It's pretty clear. That has nothing to do with the copyright damages that the owner of that image can file against you. Okay. So this guy, George Gutenberg, if we would have read the article about the Zillow lawsuit, this is the actual photographer who sued Zillow. So we talked about licensing rights, how to use photography, who has the rights, things like that. If you're like me, when you hire a professional photographer, you never read the entire contract that they sign. You just say, how much do I owe you? Here's a check, and off you go. Where do I sign? Right? Just like most of our clients. They don't read the contract, which they should. They just say, where do I sign? Almost every photographer that you've ever hired or will hire will have something in their licensing agreement, the contract you sign with them, that says something like this. You are hereby granted a one-time license to use these images in a brochure, on your website, on MLS, and in typical real estate magazines for the purpose of marketing properties. So it's where you can put it and for what purpose. This license becomes valid upon full payment of our invoice and for a period of up to 1 year. The license is not transferable to any other party. So let's talk about those things. First of all, it is a specific purpose. It's a specific time period, and it's not transferable. So the MLS, when you submit a listing to the MLS, this is your contract with C.A.R. MLS. This is what you agree to by being a participant of the multiple listing service. And I'm sure you haven't read it, but here's what it says. You, the agent, warrant to C.A.R. MLS that you own, have been assigned ownership, or have the legal authority to submit to C.A.R. MLS any and all information, text, photographs, and other media that you submit to MLS. If you are not the author, do not own, or do not have the assigned rights, your contribution, you should not submit said information to MLS. So just by taking and submitting a photograph into the multiple listing service that you don't have the rights to do, you are in violation of the MLS rules, which is a $1,500 fine. C, you hereby grant to C.A.R. MLS authority to include your contribution in C.A.R. MLS's copyrighted multiple listing service compilation. You hereby grant C.A.R. MLS authority to place a C.A.R. MLS watermark on each photo you submit your contribution. And by submitting your contribution to MLS, you grant C.A.R. MLS an irrevocable, unrestricted, transferable, perpetual, royalty-free, non-exclusive license to use, store, reproduce, compile, display, and distribute your contribution as the content. That's a mouthful, right? What does that mean? That means that C.A.R. MLS has agreements with third-party portals like Realtor.com, Homes.com, and used to be Zillow before they became a broker. So what would happen is, and you think back to that lawsuit, you take a picture, you have a photographer take a picture of your listing, you submit it to multiple listing service without the proper license, you are in violation there. You granted C.A.R. MLS the license to be able to transfer that image to a Zillow, and which you don't have. I mean, you don't have the rights, you can't grant the rights to C.A.R. MLS. What Zillow's licensing agreement used to say, and what Realtor.com's will say, and Homes.com's will say, is that once an image is transferred to them, they actually own those rights. They own the picture and can do whatever they want with it. They can send it to other sites, they can make money off it, whatever, and they own that right. Even further, the licensing agreement, when you used to submit your property, your images to Zillow, said that you also indemnified Zillow against any claim for misuse of that image. So let's go back to that lawsuit again. A photographer who was hired by the agent sues Zillow for copyright infringement. Zillow says, hey, wait a minute. I have an indemnity. First of all, I have a commitment from the agent that they owned those rights and they gave those to me. And they further agreed to indemnify me in the event of a lawsuit. So Zillow says, you can't sue me. I'm indemnified by the agent. So what ultimately happens is the photographer you hire ends up indirectly suing you, right? Kind of a mess. So how do we prevent that? That's where the property images agreement came into being, right? Again, it wasn't a form to try and make our lives more difficult. It was a form to try and protect us and allow us not to be sued by whoever owns those images. So let's assume, because most of us, I think, out there, when we take a listing, are hiring a professional photographer. And we remember that their license doesn't give us, let's go back to this. I'll do it slow so you don't get seasick here. Oh. Here's George Gutenberg's license. Remember, it was for 1 year only, and it was not transferable. So think about what happens is if we don't have the proper license. We put our property in the MLS, the photograph stays there, we get the property sold, we all then use that listing for our CMAs, right? Because pictures in the CMA are critical. It's really difficult for us to try and assess the value of a new house without seeing the condition of the old house. So what if after 1 year, we don't even think about it, right? We've been granted this license, and after 1 year, the photographer files a lawsuit against us for using their image without their permission. We don't even remember there was only for 1 year. So now we have to take those images off of the multiple listing service. Think about how ineffective the MLS would be if you had no photos, right? It's a big deal. So it's critical that we make sure that we do this properly so we have the rights. So again, this form came out 3 years ago, and I would venture to say that most of you haven't heard of it. That's why you're here today. I will tell you that even last year, I was doing training to other brokers in the county, and these were some big companies with a lot of resources, and most of them had never heard of it either. But it's important again. So here we go. Property images agreement. The process for this would be that I take a listing, I hire my photographer, and before my photographer shows up at the property, I send him this form through zip forms, and I have him digitally sign it and return it to me. And I have yet, well, when it first came out, I had a little bit of pushback from some photographers until they understood that if they didn't sign this form, I could find somebody else who would, because of the serious nature of it. But in the last, and after the first year, I haven't had a single photographer even balk at it. They just sign it with no issue. So what it says, that the important parts here are under number 4. Hopefully you can see this, okay? It's not too blurry. Oops. Grant of rights. The default, so if no boxes are checked, default is that the photographer hereby irrevocably assigns and transfers to REL, that's us, real estate licensee, all a photographer's worldwide right, title, and interest in and to all images, including without limitation, all copyrights, whether now or hereafter required. So the default is that the photographer transfers ownership of that image to us. We now own it. Some photographers will say, I'm not comfortable giving you exclusive ownership of it, but I'll give you a license for it. So you would check box B, right? Either one of these is satisfactory. Either one of them protects us and allows us to do what we need to do, but it's only an A or a B. Either we own it, or B, we have an exclusive license agreement. The photographer hereby grants to real estate licensee an exclusive worldwide royalty-free license in perpetuity, right? So not for just 1 year, to reproduce, distribute, display, prepare derivative works of art, and publicly perform the image in connection with the real estate industry. So a lot of blah, blah, blah. What it says is you can use this image for anything. Remember, George Gutenberg's license says you can use it for the MLS, but that doesn't mean I can use it for my brochure or any website or any other marketing that I do, any direct mail that I do. This license gives you the right in perpetuity to do anything you want to do with that photograph. So again, by using this form, having it signed before the photographer comes out, you either own the rights exclusively or you have the license for those. Okay. The only change to this form that's coming out next month is that we've added paragraph 7, drone use and indemnification. Because 3 years ago, there wasn't as much drone work being done. So now it just incorporates that not just photographs, but any drones, videos, anything like that are protected in this as well. Okay. So hopefully you can see why this is a really important form that should be used every time you hire a professional photographer or want to use someone else's photos other than ones that you take, right? You need to get permission from whoever that is. Okay. The last part of this down here, if you're an agent and not a broker, you need to make sure and pay attention to paragraph 10, broker identity and rights. If the real estate licensee is a salesperson or a broker associate conducting license activity under another broker's license, which most of you probably are, that broker's name and license number is as follows. So that puts in there. The next paragraph or next sentence though says, as between real estate licensee and broker, rights to images granted under this agreement shall be addressed in a separate written agreement between them. So you need to make sure that you have an understanding with your broker that if you are taking pictures or you're having a photographer taking pictures for you, that you're protected as well under that broker's agreement. Okay. Remember, if you have any questions, please put it in the chat box. I'd be happy to answer those now because we're moving kind of fast, but I want to give you that opportunity. Just type them in the chat. Okay. So I know we promised you 2 forms, the PIA and the delivery of notice addendum. This we're actually throwing a 3rd one in, like the Insu knives, right? We're giving you a 3rd one for free here. How many of you guys use an image like this after you sell a property for your social media marketing, right? You take a picture of the owners in front of the house, giving the keys, happy faces, success, great thing. It's a wonderful marketing tool, right? Do you think that's okay, or do you think you need permission from these guys to do it? You need permission from these guys to do it, okay? There was a lawsuit that a client sued their agent. They had a wonderful transaction. Everything went great. However, the agent took a picture like the one on the left with the family, with the young kids. And in that particular case, the address of the property was plainly visible. This family had a strict policy that their kids were not on social media. They didn't post anything about that. They were concerned about safety. And so they didn't want it posted on social media. They thought they never realized that that picture that they allowed the agent to take would end up being plastered all over social media with their kids, their home, and their address. So that resulted in a lawsuit against the agent. Right? I know it's crazy, but it's happening. So what did C.A.R. standard forms do? Came up with a way to protect you again, right? So this form is called the PVR. And what it does is if there's these, and look under number 4, if you have adults, children of minors, or pets, I know that's even ridiculous. If you're taking a picture and using it in your marketing and they have kids or pets, you need to get the adult's permission in writing to be able to use those images in your marketing. Okay, so PVR form, that's the bonus form. Okay, I see one question coming in there. Let me see. What happens if you hire a marketing company, you don't know who is going to be the photographer by putting ABC marketing firm? My understanding is that you're covered because that photographer is working for that company, just like you are working for the broker. If it was me though, I would have the digital one signed before they showed up at the property, and to be extra safe, I would bring the form to the property and have the photographer sign it themselves at the time, right? You're going to be there when the picture's taken. Doesn't hurt to bring one extra form. Okay. Okay. So top violations, right? The number 1 violation in the MLS is branded photos. We'll talk about in a second. Media and copyright issues. So it's not just the philosophical discussion we're having here about why copyright's important. It's the #1 issue of violation, and it's a $1,500 fine, and those don't get reduced. I mean, it's really clear that when, I'll show you some examples, when you take, especially if you take the images that another agent used in a previous listing and you don't have written permission, and not permission from the agent, from the photographer, right? Think about that. The agent 3 years ago when the property was on the market, or 5 years ago, probably didn't use this form because it didn't exist. So while the other agent might be amenable to you using those pictures and might even say, pay me a fee, right? And you can use them. If they don't have the rights because they never got them from the photographer, you just paid for nothing, or the agreement that you have from the agent is worthless. Okay. I only see the one. Okay, answered that one live. Okay. So remember, if you're going to use previous photographs from a previous listing, make sure you find out who not just the agent is. If the agent has them and gives you permission, make sure you get it in writing and see if they got permission from the photographer to use those. Okay, I get that question all the time from my own agents. Right? Hey, the agent said it was okay. They don't even have those rights. They don't even know what they don't know. Okay, branded photographs and media. This is where it gets a little bit more gray. Photos, virtual tours, and any media submitted to the MLS must not contain any branding or promotional information related to a listing broker agent. The images that you submit to multiple listing should be only about the property, about nothing else. The listing broker must also possess a proper written authorization to use the media obtained from third parties, including photographers. So things that it must not contain, right? Pictures and virtual tours must not contain the following: agent, broker, or brokerage names, or photos or logos. The pictures are not a place for you to market yourself as an agent. You're to market the property. You can't have phone numbers in there, website addresses, email addresses. For sale signs or lease signs, right? That's a common one. An agent will take a picture of their for sale sign in front of their house, thinking that's clever, and they're going to put it in the MLS, which then goes out to the third party sites, hoping that the buyer will see your name on the sign in front of the house and call you directly. Right? That's an MLS violation. Messages or solicitations, images of people, animals, or other items not directly related to the list. Virtual tours must be listing specific and must not link to agent's broker or website. Okay, so here's some examples. Some of them pretty plain, some of them not so plain. I don't know how well you can see this or not, but the one on the left here with the arrow, right down here in the bottom, it says C.A.R. MLS. They've branded this photo. So if you've taken this image of a property offline that's been branded by somebody else and you use it, that's a copyright infringement. This one here, really common. A lot of people do this. You go to Google Earth, Google Maps, you pull up an image there because it has the streets, it's great. It's a violation of MLS rules and copyright rules, because unless you have written permission, which you're not going to get from Google, I can tell you that. In this one over here on the right, the description there, right? It's not about the description, it's about the house. So those are pretty subtle, right? These are not so subtle. The one here on the left, the main photo, if you can see right here, of the house in the MLS is a picture of the agent who's taken the phone number out and his face, but he's promoting himself, not the property. That's a violation. QR codes, same thing. That QR code's taking the customer to the website, not allowed. These guys thought they were pretty clever over here, right? The MLS does not allow people's in photographs, so hence the cartoon faces. Picture yourself here, right? Lifestyle pictures. Hey, it's not just about the house, it's a lifestyle. Imagine yourself out here paddleboarding, kayaking in the bay. And so they thought it was clever by putting cartoon heads on there. Still a violation. Cute, but still a violation. Okay. Oh. These, again, more violations. Pretty easy to see. Taking a picture of this agent Salesperson of the Year plaque, right? Call them. This one here, it just shocks me, and I shouldn't have to talk about it. It shocks me how many times you go into homes and you have pictures of a spouse not wearing any clothes in the MLS picture, not appropriate. And this one over here, fortunately, they put a happy face and a star to cover that. Okay, that's not pictures of the house, not allowed. To finish this one off, just a couple of cute pictures I pulled from the MLS, right? These are actual marketing pictures of homes. Can't imagine why somebody would do that, but this is something an agent thought would be appropriate to market a home. I'm sure it's a violation, but it's also just really uncool. Okay, that's the PIA form, PVR form. Any questions so far before we go into the next one? I just see one in the Q&A. We've already done that one. Okay. Anybody in the chat box, any questions? Gosh, you guys are easy. Okay, we're going to jump into the next form. We're not going to have a lot of pictures and stuff, but it's really an important form. And I will explain to you why, especially if you are a listing agent. So let's go up here. You shouldn't see all that. That's just for me. Oops, sorry. Slideshow from the beginning. Okay. The DNA form. What the heck is a DNA form, right? It's not the DNA you're thinking about. It's called the Delivery of Notices Addendum. This form was out about 5 years ago. Its previous name was called an RDN, Receipt for Delivery of Notices. It was a similarly good form, but nobody used it. And so C.A.R. took it out of the library, which is certainly not the way to do it. We're not trying to dumb it down. We want to elevate our profession. So they brought it back in its new form called the DNA. It's been around for about 3 years as well. I will tell you that for 2 of those years, I was fighting with C.A.R. At every meeting, trying to get them to include this in the offer packet, right? When you come up with an RPA packet, it has several forms attached to it. I explained to them why I thought this should be included, and they finally listened, and it's now going to be in the newly revised RPA that's going to come out in December. So most of you, I think, are aware that the RPA, the purchase agreement, hasn't been updated significantly in more than 5 years. It's time. It will be completely revised in December, and the contents of this form will be included into that, so you won't have to use a separate addendum anymore. It's that important. Okay. So it's going to be kind of dry because we're just going to talk about contracts here, but you have, I want to use this scenario. You are the listing agent of a property today. Congratulations, right? Not many on the market. You've got a listing. You have multiple offers, and you get the property accepted, and it goes into escrow. You then have the buyer who starts having second thoughts, which is happening a lot now. I get really excited. I won the bidding war. Now I get it accepted. Now I think to myself, oh my gosh, what have I done? And they start getting cold feet, right? They become unresponsive. They haven't put their deposit in 3 days like required. They're not communicating. In the meantime, your seller is saying to you, hey, listing agent, what's going on? Why are we not moving forward? And you're desperately trying to get hold of that agent, and you can't. You get another offer that comes in unsolicited that is $50,000 above your offer. It's all cash, non-contingent, 10-day escrow with a 5-month free rent back for your seller. I mean, something crazy, really good, right? Your seller says, oh my God, this is great. I want to cancel the first deal because they're not responding. I want to go with my backup offer, secondary offer. And your seller's trying to get you to say, okay, make this happen. How do you cancel the first buyer? What can you do to get the first buyer out of the contract? Again, this is if we're in a classroom situation, we could be yelling out ideas, but we can't, so I'm just going to have to go with this. So what happens is this. The way the purchase agreement is written today, unless you use this addendum, right, the only way you can get rid of a buyer in a transaction who is not performing is you must serve them a notice to perform. Right? Hopefully you guys are all using that notice to perform. What it says right here and highlighted in D, this is from paragraph 14 of the purchase contract. Seller's right to cancel. If by the time specified in this agreement, buyer does not deliver to seller a removal of the applicable contingency or cancellation, then seller, after first delivering to buyer a notice to perform, may cancel the agreement. So let's be clear, the only way to get rid of a buyer who is not performing is to serve them with a notice to perform, right? That's the only way. If you don't, if you are unable to serve them with a notice to perform, that buyer has, in effect, tied up your property, your listing, indefinitely. I want that to sink in, indefinitely. Remember, you can't, there's no automatic cancellation, there's no time frames. Unless you serve a notice to perform, you cannot get rid of that first buyer. So you're off the market trying to serve a notice to perform to that buyer or buyer's agent. So let's look at paragraph E down here. The notice to perform shall be in writing, be signed by the applicable buyer or seller, and give the other party at least 2 days after delivery to take the applicable action. So it says delivery. It must be delivered, right? After delivery with a capital D down. What does delivery mean? Here's the definitions under paragraph 30 of the RPA. Deliver, delivered, or delivery, unless otherwise specified in writing, means and shall be effective upon personal receipt by the buyer or seller or the individual licensee for that principle as specified in section titled Real Estate Brokers on page 10, regardless of the method. So again, delivery means personal receipt by the buyer or their agent. Now, obviously, we're not going to know who the buyer is, where to find them, or have the right to even go directly to them. So our only option is to serve a notice to perform upon the real estate licensee. Individual, not the company, has to be served to them. How do I serve them? What if, and this happens frequently, what if the buyer maybe didn't get cold feet, but is scrambling? They end up paying a lot more for the property than they wanted to. They don't have all the down payment together. They tell their agent, look, just go dark for a little while. I need to buy time. Right? I need to get some money together. I need to do whatever. Don't respond to the other agent. It happens all the time. So you as the listing broker, listing agent, cannot serve the buyer. You're trying to find the agent and you can't find them. You can't go to their office. You don't know where they live. They don't answer their phone. They don't respond. How do you serve them? Absent a written agreement, there is no way. So, and this is page 10 where you put the broker's firm and buy the licensee down there. So how do you serve them? Right? The notice of delivery of notices addendum. In the contract, remember that there are everywhere that a buyer is to remove contingencies, the notice to perform is required. Right? You can't cancel without that. The only exception to that is close of escrow. You're going along fine, the buyers are all moved on their contingencies, and we just get down to escrow closing, and for some reason they just don't close. They're not closing, not responding. You don't use a notice to perform. This is the only time in the transaction we use a separate form, and it's called the demand to close escrow, DCE. So if the seller or buyer, depending on who you're representing, is not allowing escrow to close for whatever reason, you have to issue the demand to close. It's the same requirement. It has to be to the buyer or seller or their agent. It's the only way. So let's talk about the delivery of notices addendum. What this form does is there's a pre-agreement that if a notice is to be served on either party, how it's to be served and under what time frame. So there's a requirement in my company that this form is used on every single transaction. And in fact, it's used on every single counteroffer. I have templates set up in our zip forms that every offer that comes in, because I will tell you that 999,000 out of a million offers that would come in, one of these forms would be attached. Normally it's not. So we virtually have to counter every single offer, even if everything else is right. We have to counter this. And again, remember why. If we can't serve, as a listing broker, if we can't serve the other side of notice to perform, we can't cancel that escrow, and therefore that property is tied up indefinitely. So this really needs to be done at the time of offer presentation, because think about it. If the buyer, you're a listing broker again, if the buyer is not performing and your seller's screaming at you to get that deal canceled so they can take the better offer, do you think that preparing this form, giving it to the buyer's agent to sign, allowing you to serve them a notice of perform to cancel, are they going to agree to that? Heck no, right? They don't want to be found. They're not going to agree to this form. So unless it's done at the time of the offer or counteroffer, it's really worthless. That's why it's being incorporated into the new RPA coming out in December. Okay. So what it says is, fill in the property information buyer seller up here, that number one, delivered or delivery, regardless of the method used, means and shall be effective upon the earliest of personal receipt by the persons or as specified in this agreement. So you can do 2, mail delivery if you choose to mail it. I don't recommend that. I always check box 3, email delivery. But you have to know that there hasn't been a court case yet that has deemed that email delivery is sufficient. I can prove that I sent you an email. I can't prove that you got it or you read it, right? Unless they reply, right? So I can't prove that again. So if you're going to do email delivery, you check the box, there has to be 2 forms of notification. Notice sent by email to the address number 1 below and shall be deemed received 1 day after the email was sent. Provided that a copy of this notice was sent to on the same day to email number 2, the text number or fax number specified below. So what that means is I can send the other party a notice to perform by email as long as I do it by a second form of communication, which is either a second email address, right? Some people have a work address and a home address. I can do it to both. And the courts have deemed so far that that's sufficient. I send it to 2 different email addresses. Or maybe some people don't have 2 email addresses. They have 1 email and everybody has a cell phone, right? So I can put a text number in there. So I send them an email notice to perform. I send them a text or a fax. So as long as I have both forms of delivery, that's sufficient for the contract to say you have delivered that notice to perform. Okay, so it's imperative that when you're doing this, if you're writing the offer, you fill in both agents' information. You have an email address and you have their text number. If you're the listing agent and you're countering the offer, you definitely want to make sure that you have on the buyer's agent a email address 1 and 2, or email and a text, or email and a fax. It's critical. That way I know I can prove that I actually sent it. So the question I asked when this form first came out to one of the C.A.R attorneys, he said, does the text have to be exactly the same as an email? Right? I can email an attachment. I can email the PDF attachment of the DNA form. What about the text? Can I just send a text that says, hey, agent, I've emailed you a delivery of notices addendum or a notice to perform, please check your email. Is that sufficient? And frankly, they didn't have an answer for that, right? They said, until a judge rules, we don't know, but that would be hard to argue that they weren't notified. So again, email and text, email and email, email and fax. Make sure you're putting in all the information for both parties. Everybody signs it and incorporates into your offer. How do you do that? The way I teach it is under paragraph 5 of the purchase agreement. Under addendum, it's not an advisory. Don't check under box B there. That's just an advisory. Under paragraph 5, addenda and advisories, I check the box for other, and I type in delivery of notices addendum, and I attach that form. What that means is that it's incorporated in and becomes part of the contract. It's just as important as any other page in there, right? A lot of times you'll send that out as an offer, it doesn't come back. The question is, if that doesn't come back, do you have a deal? The C.A.R attorneys that I've talked to, in my opinion, no. right? You don't have a meeting of the minds. It's just like they didn't sign page 6 or 7, right? To be a binding contract, you need to have the meeting of the minds, which means you both have to agree to the same thing. Well, if they haven't signed the delivery of notices addendum, which is incorporated into the contract like anything else, do you really have a meeting of the minds? Question. By emailing to other party agent and CC to yourself should be equally sufficient. Emailing to other party agent and CC yourself. All you have to be able to do is prove that you sent it. So if you can prove that you texted it and you prove that you emailed it, that's sufficient, right? A lot of times they're not going to respond because they don't want to, but you just have to have a paper trail, something that you can show that it's not just telling a judge, yes, I sent it, right? He said, she said, that doesn't work. So whatever you can do to make sure that you can prove that it was delivered to the other side, right? I take it a step further. I'll send them a text. I'll send them an email. I'll call the other agent, leave a voicemail. I'll document all of that in my file, the dates and times that I did that. Because if it's to the point where I'm trying to cancel a transaction, it's serious. I want to make sure I've used every tool in my arsenal to prove that we delivered that. Right? Because the other side is going to say, I never got the email. I never got the text. Right? I never got whatever. Right? And you can say, reply to this and acknowledge it, but they're probably not going to. So just make sure you've done everything you possibly can. Okay. Okay. So in the offer, this is how I attach it. In a counter offer, right? I do the same thing. Under number D, the following attached addenda are incorporated into this counteroffer. So it's just as important as price, terms, anything else. Check the box, delivery of notices addendum, and it goes back to the buyer. Okay. That's it. We got some time for questions. What I'd like to do is go back to gallery screen if I can. And I'm going to ask, I don't see everybody. I'm going to ask, Shirley, can you unmute everybody and see if we can do this? Jennifer, wait, does the DNA form protect equally both buyer and seller? Yes. What I would say is that more often than not, the listing is more important to the listing broker because generally you're trying to keep the buyer in line, right? Very few times a buyer is having to force a seller to perform, but yes, it protects you both, right? That's why it's important to have it. Even if you're writing the offer, make sure that you have your information as well as the other agent's information in there. Okay. I don't see any more questions there. Anybody have a live question? Go ahead and unmute yourself and or raise a hand or do something. I miss seeing you all in person. It's really tough, I gotta tell you. Open questions? Okay. Hopefully that meant something to you guys. Again, if it has been recorded. If you want to go back in the library and check it out, if you want to tell other friends in your office, other agents, do that. You can always contact me. I'll be happy to answer any questions that you have. I'm just real easy. It's chris@cvvillage.com. And we'll wrap it up. We'll call it a day. Thank you guys again. I really appreciate your time. I know you're all busy, but we have to make sure that we're on top of our game. And these two forms are, as you can tell now, are really important for not only your protection, but for the protection of your clients. Okay. So everything that you can do to make yourself better, make industry better is a good thing by me. All right, guys. Thank you again. And look for this on NSD. I think she put it in the chat up there, right? If you look in the chat,
yes, it's in the chat. And also everybody is able to unmute themselves if they want to talk live and ask a question.
So do we get a recording of this to go over again?
It will be, if you go to, there's a website.
Okay.
The association created a website that has a YouTube channel actually that has all this and every other recording class, a lot of things that we did last year, all the chit chats we did are all there. It's at nsdcrealtorstv.com. It's in the chat
Oh,
there.
yeah.
You'll be able to
Okay,
see.
yeah, I've been there. Okay. So it'll be on there too. Okay.
Yes, they will.
All right. Thank you.
You're welcome.
And thanks for your time. Appreciate it.
Oh, my pleasure. Thank you.
I like that form, the DNA.
It's good form. Yeah. If you're a listing broker, I can't imagine having to look my seller in the eye when we have a great other offer and he says to me, why can't you cancel on the first one? And you have to say, well, because I didn't use this form at the time of the offer. That would not be a good conversation, right?
Well, I bet they don't even know it's there, most listing agents.
They don't. But I'll tell you what, that seller will find out by talking to somebody that it could have been easily prevented with this. And who do you think they're going to come after?
Yep. Makes sense. All right. Y'all have a great weekend.
All right, you too. Okay, guys. Thank you. No more questions. I appreciate it. See you next time.
Thank you, Chris.
You're welcome, Shirley. Thank you. Thanks, Dana.